Justice Robert Brennan. And let's just proceed with the first case on the list, Commonwealth versus DEVAUGHN Johnson.
Thank you, Your Honors. Suzanne Renaud for DEVAUGHN Johnson. Your Honors, this is obviously a case dealing with accessory after and what those elements really mean. And I would like to start with this element of knowledge, because you have to have knowledge of the specific crime, at least the facts that would make up the specific crime, before the person could be found guilty of it. In this case, it's armed robbery. It's not assault and battery with a dangerous weapon. It's not murder. It's armed robbery specifically. And the Commonwealth's supposition in the first instance is that Mr. Johnson knew about a plan to commit an armed robbery prior to them going into the victim's home. I don't think that that's borne out by the evidence. I've gone through that in my brief. I don't want to belabor the point, other than to say that Ms. Phalanges very specifically said that they were going there to buy weed, not to steal it, but to buy it. And you can't completely reject the evidence that is presented by your own witnesses, especially when it's backed up by the video evidence here and some of the other evidence. I mean, the fact that somebody is carrying a pocket knife, the trooper or the officer who identified this as a pocket knife carries one, that isn't indicative to people automatically that a armed robbery is going to occur. And so without anything else, it's just a theory of the Commonwealth, and it's a speculative theory. So I think you have—
What about the video showing your client opening both front doors of the Toyota?
Well, so Your Honor, that comes after. I think that the point of that is that, did he know something was about to happen or was going to happen 20 minutes before he opened those doors? I don't think that is established by the evidence. But what I think is established is that he sees his two friends sprinting down the street. I think that is very obvious. And I had to remind myself this a couple of times. This is not like a police officer dealing with reasonable suspicion. This is actually having knowledge of the elements of the crime. So if Mr. Johnson sees his friends running down the street, which he clearly did, that's on the video, and he pops open the doors. Now, whether or not that's material enough assistance is a different question, but in terms of knowledge, I don't think the fact that he is reacting to seeing that is proof that he knows that a larceny occurred, an armed larceny occurred, something that's other than the fact that something happened to his friends.
So let's use that as a starting point, because I don't necessarily disagree with you, and I might even still be with you, but when I watch that video, and then you put it in the context of the testimony, so starting point is when they hop in the car, bloody. One guy's got what it looks like in the video to be pretty clearly a knife, an extra backpack over his shoulder, and then it was, again, the technology now is remarkable, but the slowdowns and little vector signs and bulging pockets. I didn't see the cash going out, but I didn't see it myself.
I would disagree about the bulging pockets part.
Yeah, so that's what I'm saying. So, but putting that aside, why isn't that enough? In the light most favorable to the Commonwealth for a rational juror to infer that you knew they just robbed a drug dealer?
So I would say, Your Honor, I mean, just to be very clear, you have to say that the person had knowledge enough to piece all of this together. If you look at the video, the bags that we're talking about are over his left shoulder. How does he know that those were stolen in the first place? I mean, I think that that's the first logical hurdle you have to overcome.
They say go in with one, come out with two.
Well,
and
I
then they
believe
get
he
in
went
the
in
car with two.
I believe he went in with nothing, and it's not
nothing,
clear that there are two that he's holding. I mean,
That's
obviously
fair.
we know that he's holding two because of the benefit of hindsight. But again, he went in to buy weed, and he comes out with a bag. That doesn't necessarily mean that it's an armed robbery. And I think then the next piece is that when he's popping the doors, it's dark out. It's hard to see, like Mr. Trongo is found later on to be covered in blood. He has a bleeding cut on his hand, and he is holding a knife. But to be able to register and to put all of those things together to say that this wasn't an assault and battery with a dangerous weapon, or this wasn't just a larceny, that this was actually an armed robbery that had occurred, that he is providing assistance for, I think is a really big stretch based on the images. And just to reiterate, this is about 2 seconds, 3 seconds of people sprinting down the street that he's reacting to.
Well, at what point did the Commonwealth have to prove the defendant's knowledge?
Before he provides the assistance, because or at least concurrent with the time that he's providing the assistance.
Or he starts providing any assistance?
So, well, I mean, I'm not sure I'm following your question. I think that in terms of statutory construction, that if you have knowledge after the action, there's no concurrence, and so that would.
But there's more action, right? There's more assistance than that.
You're referring to the hotel, the motel.
Right.
Yes, and I wanted to start here because if you can't establish this car door part of it, then he at least gets a new trial, I would say, because that's insufficient evidence on part of their theory. I mean, this is, again, part of the theory of the case that they are, that they're going on. So that, I think, is significant on its own right. But yes, we do have the next step of the matter, which is what happens in the motel and about knowledge regarding the motel. This, you know, I take your point that he just saw something happen, but I think this is where the speculation, and I really, there's clearly a line here that we're dealing with between making sure that we take facts in light most favorable to the Commonwealth versus saying that, you know, they have to actually have some kind of foundation to prove what their theory is.
What about the fact that the drug customers in the hotel
Yes.
saw Tronjo covered with blood in
Yes.
his white clothes? They saw him
Yes.
with a knife in his hand, and they
Yes.
asked what happened.
So
So doesn't that show that a bystander would put two and two together here?
no, Your Honor, it doesn't show that they know about the armed robbery. That's what this is all coming down to. I would actually even add to this, because
So you're saying theoretically, if he hadn't been found not guilty, better case for accessory after murder, better case for even accessory after ABDW?
ABDW, I think ABDW is.
You're saying it's the larcenist part of it that
Yes.
is speculative.
That's the part that's speculative. And I think in order, this is actually a really interesting thing. When we're talking about the motel, the thing that he's actually accessorizing, because the first thing you have to say is that he is providing concealment or assistance, period. What is he actually trying to conceal or assist? If we're going to take it, you know, he's concealing the blood. It's not the bags. Bringing bags into a motel is not something you're actually providing assistance or concealment with. It's the blood. So in order for this whole thing to track, Mr. Trongo has to be a joint venturer in the armed robbery. So it's not simply enough that there is a connection to Mr. Henderson. Mr. Henderson doesn't have any blood on him, really. I know Ms. Phalange, and I take issue with the Commonwealth's brief, which says that he is also covered in blood. That's not the testimony. That's not in the transcripts. Ms. Phalange said that he had a little bit of blood on him, but I want to point out that we also have the black clothes in evidence, and they do not show
DNA
blood.
testing on the black clothes that were found in the dumpster?
Those spots were very small. There was blood. Some of it was in his underwear. The very small spots on his black clothing. He is not, and also the men from New Hampshire said he did not have blood on him. The only person who had blood, the thing that you're hiding is Mr. Trongo with the big cut and the steak knife and all of the blood. So if he is not found, or if there is not a connection of him to the armed robbery as a joint venturer, then, or knowledge, I should point out, it's not just enough that he'd be found guilty theoretically. It's that Mr. Johnson, who later on said Mr. Trongo committed a murder, and Mr. Trongo's admitting to a murder that had nothing to do with an armed robbery, there has to be a way to say that Mr. Johnson knew that Mr. Trongo also committed an armed robbery. Because otherwise, this whole thing, there isn't anything there. There isn't the knowledge of what he is assisting, of the specific crime that he's supposed to be assisting. And Mr. Trongo is not, none of the evidence that the Commonwealth put forward is suggesting that Mr. Trongo committed an armed robbery. Now, Mr. Henderson might have, under the cover of Mr. Trongo's actions, committed an armed robbery. I don't, you know, I'm going to leave that jury verdict for him to argue. But in terms of Mr. Johnson's knowledge, we don't even have the benefit of a jury verdict here because Mr. Trongo had died, which
What
is...
about that? I know you throw it out there, and it's actually a kind of an interesting argument. I'm not sure I'm buying it, but the
Well-
factual impossibility of a conviction.
Your Honor, it is so strange, and it's because this is such an old statute, and if you read back on the treatises, you read Perkins, you read all the cases cited by Perkins, you read the Supreme Court case, And we look at the appeals court decision that had to deal with somebody being found not guilty. It is weird. It is strange. I think even Perkins says this is strange. I don't remember on what page
I mean,
it
if he had been tried earlier and found not guilty, then
then he would have,
the
yes.
accessory goes away.
And I agree with you. It's uncomfortable. It doesn't really comport with how we deal with law these days, but it's the law.
But Perkins is a 1941 law review article.
And it's been,
And since then, we've had a lot of law from the SJC clarifying joint venture and accessory, and we have things like surveillance video and cell phone evidence and DNA that puts people at the scene of the crime. So why are we relying on a 1941 article?
because, Your Honor, we have specifically said over and over and over again that this is a common law crime. We're following common law. And Iacoviello, which was decided in 2016, followed this general principle. So I don't think that I am stretching the law. We are following the law that as existed in the 1700s, and it's because that is what continues to exist. And
Maybe it's sort of an equitable argument that if the principal isn't possible, you can't convict the principal, why should the accessory be held accountable?
Right.
I don't know.
Because I think, if you read the statute, the first thing is that they actually have to provide assistance or concealment. And I suppose if the person is never going to be guilty, then there's no assistance or concealment that could have been provided. At least I think that's how the theory bears itself out. It is, I'm putting that to the court. I don't want to belabor it again because I do understand why it doesn't really fit with the way that we think of how laws usually are written, but that is there. But I think it still is worth pointing out here that if Mr. Trongo is not a joint venturer in the assault, in the armed robbery, and I think that it is speculative based on this evidence to say that Mr. Johnson would know that he was, given all the other things that the Commonwealth itself put into evidence, then you don't have knowledge that the thing that he is trying to hide, ostensibly, is an armed robbery. And that, I think, is the significant piece of this here. If I can, in my last couple of minutes, unless you have further questions on that, I do want to talk about this materiality, or I don't know if materiality is the right word, but the idea that underlies an accessory is that there has to be something. There has to be some tendency. Again, I want to point out at Perkins the cases that it cites to. One of the cases says that it gives a list of examples that come from Blackstone, and then it says, this and such like assistance to one who is a felon. So in other words, they're looking for things that are of that caliber, of that level of providing a horse. And to, beat a dead horse metaphor, basically, to say that what Mr. Johnson here did at most was they had their own horse, they put their horse in front of people who could have exposed them, and they're not concealing themselves. But at most, he gave them a leg up on a horse that they already had, that they could have gotten up on themselves. That doesn't fit with the level of seriousness that we have come, that is expected under this law. Again, there is a case that it's a Texas case, Jones versus State, which cites to Wharton, that is a case that's cited in Perkins. So I know that I didn't cite it in my brief, but it's citing to Wharton, which has been around for a very long time, which also talks about there being a level of significance, and I, of course, can't find the case citation at the moment, but there has to be a level of significance to the assistance that is being provided. And I think that opening a door, especially one that they are opening themselves, because I would like to point out that I think it was Mr. Lewin said, oh, they opened the door themselves. Not only did they expose themselves with the blood, and they could have chosen to do differently, they're opening the door themselves. So before we even get to really what the
who's
specific...
opening what door themselves?
They opened the motel door themselves, according to Mr. Lewin.
Yeah, the card, right? Yeah,
With the key card.
Yeah.
And you could see from the video that he had access to the key card, and they were coming and going, and that's the door they chose, and common sense tells us...
We can watch the video and decide if we think it depicts
Yes.
your client opening the door.
Well, you can't see it. Whether he opens the
And
door.
whether or not we consider significance to the fact that he sauntered through the lobby and then speed walked once he got around the corner.
Yeah, so, Your Honor, what I would say is it is clear that he goes there, and it's clear that I think that he's trying to open the door, but the point of the matter is that when you get down to it, if they have already had the ability to do it themselves, what
about the fact that he gave the drug customers marijuana from the duffel bag in exchange for giving him a ride to elsewhere in Haverhill and Henderson a ride to New Hampshire?
Well, I see I'm over, but the answer to that question, I would say, is that when we're talking about knowledge, it has to be knowledge of the crime before the assistance is given. If that piece of evidence tipped the scale into saying that Mr. Johnson then knew that this was stolen marijuana, okay, but it doesn't really bear on the action that he had taken 20 minutes prior, I would say. So with that, I thank you. I would ask to consider my brief and to enter an acquittal for him.
Thank you.
Good morning. May it please the court, Marina Moriarty on behalf of the Commonwealth. Your Honors, I will start with the sufficiency of the evidence regarding the defendant's knowledge of the armed robbery. I would first point out that the defendant need not have particular knowledge with respect to every element of the armed robbery. The case law is clear that the defendant need only know by observations or information transmitted to him of the substantial facts of the felonious crime. And I would suggest that the substantial facts start in this case with all inferences in favor of the Commonwealth well before the time the defendant is sitting outside 10 Marble Ave in Haverhill. As an initial matter, the defendant is...
Can I ask you, if there's evidence that he shared the intent, essentially the joint venture or now aid and abet elements, does that preclude a conviction for accessory after?
I'm sorry, can you repeat?
No, if we presume that he was actually the driving force here, and that really, rather than being an accessory after, he was either the driving force or at least an aider and abetter in the actual crimes, does that preclude then him being convicted of accessory?
I think the case law is that as accessory after would be a lesser included of the joint venture liability.
That is a better way of answering my question that I was asking inarticulately. Thank you. Yes.
So first, the defendant is the one who is most familiar with the victim in this case. The defendant's family specifically testified that the defendant was over their house multiple times. The defendant's father said that the defendant ate food off of his plate. So it's no coincidence in the Commonwealth's view that it was the defendant who sat in the car waiting, because he would have been the one who would have been most likely to be identified by the family. Additionally, when Caden Henderson, you can see in the video, when he went up the stairs to the apartment, he was not wearing a mask. But when he entered the apartment, when the victim's sister answered the door, she testified that Caden Henderson was in fact wearing a black type, COVID type mask. So I would suggest that that is additional evidence that there was some nefarious activity and a plan on that evening. With respect to the armed robbery portion, it's evident that Caden Henderson had a knife visible as he was walking into that apartment. Additionally, it was the defendant who would have benefited from this armed robbery, because the defendant had made plans with Christopher Lewin and Gavin Peralt to sell exotic marijuana. And of course, the defendant would have known that the victim would have had access to this exotic marijuana, which he did in fact have in his apartment, as Trooper Strong testified, because there was, once they opened the safe, there was notation that mentioned exotic. So of course, I suggest that those factors, just leading up to the car pulling up at 10 Marlborough Road, suggests that the defendant was in fact knowledgeable about this armed robbery that essentially went bad. There's evidence that David Trongo went to the bathroom to psych himself up before he went back into the bedroom to commit the violent act. The Caden Henderson and Trongo entered the apartment with no bags. They came sprinting out of the apartment with 2 duffel bags. David Trongo was covered in blood. is no coincidence. It's evidence that the defendant, in fact, was waiting in the car with the car running, with the lights on for the 23 minutes it took his two co-defendants to be in the apartment. He was waiting because he expected them to come out of the apartment and open the doors. So I would suggest that all those factors there are sufficient to establish that the defendant had knowledge of this planned armed robbery, and that his first piece of assistance was popping open those doors. But even if that's not sufficient, once the two co-defendants got in the car, surely at that point the defendant had knowledge of what had just occurred. There was.
What do you make of the argument, though, that sure, they would have had knowledge and the evidence was there to infer knowledge of an assault and battery, or assault and battery by means of a dangerous weapon, or even a homicide, but the robbery part, the stealing part of it is lacking.
This wasn't an intent to go and beat up the victim. This wasn't an intent to go kill the victim. The plan was, and the witness testimony isn't that they were going to buy drugs. The witness testimony was that they were going to smoke and quote unquote get some weed. Of course, there was no testimony that they specifically planned to rob the victim.
Yeah, I'm not sure. I think get to steal or rob is perhaps a speculative leap that we can't take.
Perhaps, but certainly she didn't say to go buy some weed. So the whole plan that evening focused on the obtaining marijuana, because the defendant needed to have marijuana to sell to the clients that were coming to the hotel that night. So there would have been no purpose, no point to just go beat up to go beat up the victim. There would have been no point to really kill the victim. The point was for these defendants, because this particular defendant knew that the victim had access to marijuana. He would have known, the father testified that he had $30,000 in cash, that he was a mechanic. This defendant would have known what was in the victim's apartment that night.
And since this defendant knew them better, it would have made, and if he was just going to make a financial transaction, a business transaction, he would have been the one to go and make that transaction.
Yes, exactly, if he had cash to buy the weed. But apparently, these three co-defendants did not have any cash, and so the plan was to steal it. And how do you steal weed from a weed dealer? You don't just go beat them up. Henderson had a knife that was visible. Obviously, Trongo also had a knife. So I don't think this plan was to go and beat up the victim. The plan wasn't to go murder the victim. The plan was to go steal and commit an armed robbery of the marijuana. And surely that he knew that that's what had happened once they got in the car with bags full of marijuana, blood on their clothes, and pockets full of cash.
Without getting too hung up on the issue, let me ask you a hypothetical. Assuming for the moment Henderson's out of the picture, and it's just Trongo and Johnson.
Sure.
Okay? And then Trongo dies.
Sure.
A week after. Does the accessory after, is it still a viable indictment?
Absolutely, and I would suggest that it is, even back into the 1930s case law. I would suggest that the case that I cited in my brief, Commonwealth v. Bloomberg, it's a 1939 decision by the SJC, and it talks about accessory before the fact. And I didn't quote this portion in my brief, but I'll just quote it now. It was necessary in proving this new statutory offense to prove the guilt of the principal, but it was no longer necessary to show his conviction. And I think that's the point. A crime needs to have been committed, and I think that's the point in
What if he were acquitted? Instead of passing away, what if he were acquitted, if they were either tried together or if the cases were severed for whatever reason? They go on the substantive offense first, defendant's found not guilty, do you still go forward on the accessory after?
Yes, I do think that just like joint ventures, one joint venture can be found guilty, one joint venture can be found not guilty. I think the case law, the modern day case law is clear that as long as there is sufficient evidence to convict the defendant before the court, and so in order to convict the defendant of an accessory before or an accessory after, the Commonwealth would have to prove beyond a reasonable doubt that a crime was committed. As long as there's sufficient evidence with respect to that particular defendant before the jury, that there no longer needs to be a conviction and that an acquittal is not a bar to a trial. And again, I do think that even if the evidence is, which the Commonwealth suggests is sufficient to show the plan before the car arrived at Marble Ave, I think once the defendants got in the car, there was absolutely no, there can be no reasonable doubt that a reasonable jury could find that at that moment, the defendant surely knew about what had happened, and that his actions thereafter in preventing his co-defendants from needing to walk through the front of the hotel, and what can be argued was witness intimidation of the two drug buyers in the apartment, was sufficient to meet the requirements of aid and assistance as an accessory after.
What about the bus ticket? The evidence that he bought a bus ticket for Henderson, or gave Henderson money for a bus ticket.
Sure, I mean, I think all of that goes to his intent to, that's, I think, the last prong. It's aid with intent to help the principals get away with the crime. Said less eloquently than I had hoped. He clearly intended to help Henderson. He clearly intended to help Trongo. He clearly intended to help himself, and I would suggest that there's consciousness of guilt evidence in the false statements that he made to the police, in the not very veiled comment to his brother when Trongo was arrested, and he told his brother to tell Trongo to keep his mouth shut in jail. I would suggest that the evidence after is clear that his intent was to aid the principals in avoiding detection. And if there are no further questions, the Commonwealth is happy to rest on its brief.
Thank you.
Thank you.
Thank you both. At this point, the next case on the list is Commonwealth versus Joseph Green, 24P504.
Good morning, Your Honors. Jennifer O'Brien on behalf of the defendant, Joseph Green. As you know, the issue in this case is quite simple. It's an ineffective assistance of counsel claim made by the defendant for trial counsel's manifestly unreasonable tactical decision to introduce the one key piece of evidence that ultimately convicted the defendant. I'm sorry.
I'm just at the clock.
Okay. So, viewing the evidence in a light most favorable to the Commonwealth without this McKenzie video, which is the video that was introduced, the Commonwealth had evidence that on October 4th, 2021, sometime between 5 and 9 p.m., a paint can was thrown from a white vehicle onto the victim's driveway. The defendant's vehicle drove past the victim's residence at 8:03 and 8:17. And when the police went to the defendant's house to question him about it, he admitted to being in the Rosewood neighborhood and seemed very nervous. That was it. I think the Commonwealth, in its brief, is arguing that somehow that without this McKenzie video, there still would have been enough to convict the defendant. But
Didn't the judge signal that? Who, in fact, not only was the motion judge, was the trial judge, not just the trial judge, but the finder of fact is that it was a bench trial. Seems to me in his memorandum of decision, he, without coming out and saying it, because again, as he should have done when he rendered his verdict, he simply said, found the person guilty, and didn't say, oh, it was because of the little thunk or the thud or the whatever the noise was. And he says the circumstantial evidence at the time was such that how can you blame him? At least let's Hail Mary. Let's see what we got. Put in this best, as he said, best offense or defense is a good offense, I think the judge said.
Well, I don't know that he didn't obviously say what made him find the defendant guilty, but I strongly disagree with there being enough evidence. I mean, this is a 4-hour window. The victim went out at 5 o'clock and came back at 9, and sometime during 4 hours, a white car drove by and threw paint onto her driveway. So the fact that the defendant drove by her driveway twice during this 4-hour window and has a white car, I don't understand how a jury or the fact finder, in this case the judge, could possibly convict him based on that and nervousness when he was spoken to. The police went to his house that night. There was no paint on his car, no evidence that there had been any paint thrown out the window. There was no video otherwise introduced that shows who was driving, that it looked like him.
What do you say about the fact, couldn't the video have come in anyway, even without the assent?
Well, two things I have to say about that. The ineffective assistance of counsel here wasn't the fact that defense counsel stipulated to the video. If he had stipulated to the video and the Commonwealth introduced it, then I'd be arguing something different. It really doesn't matter. I mean, I wouldn't concede that there was enough for the video to come in anyway. They didn't have the proper witnesses, and I understand the cases that were cited by Judge Hildman, the Davis case and Cindy Van Tran. I would argue that those cases have to do with circumstances that are more unique. In one case, there was a witness who saw a shooting, and there was the officer who obtained the video, and you can see the shooting happen, and then he found the shell casings where the shooting happened. There was more to piece together. Here we have a video, we have that it was raining out, and we have that there are cars driving by. The most important part, or the most unique part about that video, was the fact that a white car drove by 14 minutes apart. I would argue that that's probably the strongest argument for the Commonwealth.
Let me ask you, if we disagree with you, and we were to look at this and say that evidence that your client's car drove by twice, which is video evidence with the license plate and his admission.
Yes.
The fact that it's a white car in an SUV, the fact that the other video that shows the paint splat comes from a white SUV.
Yes.
And your client appears to be nervous when he's talking to the police is enough in the light most favorable to the Commonwealth for a rational fact finder to, given all the inferences, find beyond a reasonable doubt that he was guilty. Then if we were to disagree with you and find that, you agree that that's the end of the story, pretty much. Then you don't really have much to go on.
Probably, yeah.
Okay.
Yeah, I don't see how, I mean, the Commonwealth notes in its brief that the defendant didn't introduce any videos of other white cars. The Commonwealth the defendant does not have the burden of introducing any evidence, right? So if this video didn't come in a 4-hour time period, how many white cars could have driven by this person's house was open-ended. Introducing that video made it.
But in deciding whether defense counsel fell below the standard of an ordinary fallible lawyer in introducing the video,
Yes.
if a piece of evidence is in some ways inculpatory and in some ways exculpatory, what do we do with that? Is a defense attorney always ineffective to introduce a piece of evidence if it has any inculpatory interpretation?
Absolutely not. I think if, in this case, if the defense counsel knew what he was introducing, knew about the audio, and made that tactical decision, then I wouldn't be here. In this case...
Your position is that the audio does it. I mean, honestly, there was a lot of raindrops. There were little noises in the other videos. I guess there's a plunk or a thud, or I don't know what people call it.
Metallic thud.
Metallic was strong.
I mean, I listened to it at my office, and I thought it was pretty obvious and pretty clear.
Okay.
I think certainly we can't play Monday morning quarterback and say, well, you shouldn't have introduced that because it happened to come back and bite him. In this situation, it was an uninformed tactical decision. He literally didn't know the inculpatory portion of that evidence that he was introducing.
Didn't the judge even comment about how faint that was, the sound?
I think the Commonwealth argued, and I don't recall whether the judge did. The Commonwealth definitely did. It was heard. I mean, you could hear it. And the Commonwealth also argues that it should have been introduced because there was a clear thud on one video and you can match that to the other video, therefore it would have been properly authenticated. So you can't really have it both ways. I heard it, obviously, you all have the exhibit whether or not you hear it. It's no question, just from looking at the Commonwealth's closing argument, that this was the key piece of the evidence that they were able to use to convict the defendant. I don't see how this court can disagree with me, obviously, but if somebody goes out for 4 hours, they come back, they know a white car did something to their property, and they have evidence that somebody in a white car drove by twice and was nervous when the police talked to him, that it has to be them. I just don't see how that connection can be made. So here, I think most of the cases that I've looked at are when someone, the defense attorney doesn't introduce something or doesn't claim a defense. Very few cases are where they introduce something that really just kills the defendant as far as the case is concerned. So if there are any other questions, I think it's pretty clear what the argument is, and we'd ask that you give the defendant a new trial. Thank you.
Thank you.
Good morning, Benjamin Haspel, Assistant District Attorney, Middlesex County for the Commonwealth. I was the trial attorney in this case. The McKenzie video, or this video from across the street, if we want to characterize it as defense counsel introduced it through the cross-examination of the Commonwealth's first witness, the victim, concretely and definitively allowed defense counsel to argue that there was more than one white SUV that went past the house on this quiet suburban road in the relevant time period. As Justice Hillman, who was both the bench trial judge and the motion judge, found that this was a reasonable and strategic decision by defense counsel as early as motions in limine in this case.
To the point defense counsel made is that how can it be a reasonable strategic decision if you don't know all the variables? If you weighed it and said, okay, there's a little plinky, clunky, whatever that noise is on the one hand, but wow, we got 4 cars that look like my guy's car driving by. Okay, that's a strategy. But when you know one thing, you don't know the other. How is that a strategy?
So I think there the answer is, as the court kind of focused on already, is that the video itself, I don't want to overstate exactly the inculpatory nature of it. While ultimately it was argued in light or in conjunction with the other evidence in the case, the video itself does not conclusively prove that it was the defendant who did this. It requires accepting first that audible noise is a thud, accepting that that audible noise is the paint can being thrown, and accepts that the time period, that 14-minute time period, is accepted and is established as being the defendant. So it's not the case where, for example, from this vantage point, that we can see that this car with the license plate is the defendant's car. We can't even see that the defendant is the one operating the car. As defense counsel really focused on in his closing when he made his 3 points, his first point he makes is not even that there are multiple cars going by. It's that you don't really have the Commonwealth doesn't have the malicious intent, this actus reus intent or element of you can't see the defendant actually throwing the paint can. He makes a big deal in cross-examination, for example, of the neighbor witness that that day was trash day, and so he makes this inference that the paint can might have been on the street. So that was his first argument in closing. And so the reason I say this is the video, the McKenzie across the street video, doesn't conclusively prove that it's the defendant. It only works if you accept a lot of these other things and all the inferences that can be drawn from it.
Your position is that without that video, still enough to get over the rail?
I think so. I think that the evidence that this isn't the case where defense introduced this, for example, in his case in chief, but take this video out, going to the second prong, what you do have is a white SUV going past the residence. You can see in the victim's video that the paint can ends up on the driveway on the car. There's testimony that the white SUV, a white SUV belonging to the defendant, drove down that street. Police that night go to the residence. There's a white SUV, the white Mazda, sitting in the driveway. He admits to driving the car, and we have a police lieutenant, I think he testified 23 years he's been on the job, that he was nervous and is answering while they're sitting in his living room post Miranda. So I do think that there was
no motive, right? There was nothing established as to why he would do this?
So, no, there was a motion in limine that was filed by the Commonwealth as to prior bad acts. That was obviously denied. It was also raised by the Commonwealth in an objection after the closing to that kind of lack of accident to defense counsel's first point. But no, nothing definitive on the record.
Do we have that motion in limine in your supplemental record appendix?
I don't think the motion in limine itself, no. It just came up through the oral argument in the early parts of the transcript. But what we do have is at least some previous relationship between the defendant and the victim. So when we talk about taking this video out, if this then allowed defense counsel to argue, well, how it could have been any number. There's lots of white SUVs out in the universe, out in the town of Billerica, that could have driven past this residence. Well, at least there was some connection, that this wasn't just a random targeted attack. There was some evidence that they were formerly neighbors, that there was some relationship between the party. Why, on this date and time, a paint can was chosen to be thrown, that wasn't in the record, no. At least to the piece then about the authentication and whether or not that prejudices the defendant in any way. I do think that Justice Hellman was correct in citing those cases, that there was enough evidence otherwise, even without Detective Taylor there or a resident of that house. Lieutenant Mirasolo also testified that he did review the evidence in this case, but there was an acknowledgement from the victim that this was a vantage point from her across the street neighbor. It was nighttime, it was raining, it was dark. And of course, the timeline of the cars match up. We have that 14-minute interval. And as defense counsel said, while it wasn't time-stamped, this video, there were a couple of references that this was from 8 p.m. to 8:20. And so when you compare that to the definitive time we have on Mr. Ferrari's, it's at 3 minutes and 17 minutes, so 8:03, 8:17. So there was enough, I think, sufficient corroborating evidence to authenticate it. And even if there wasn't, I don't think that rises to the level of prejudice to warrant a new trial and really overturn the conviction. The case of the Adams case, for example, that defense counsel cites, or excuse me, Day is defense counsel cites, that was a case where it wasn't really about authentication, but the picture itself was prejudicial. It was unsanitized, and so the answer there from the court was, well, there was no reason to have the fact that this was a booking photo at a jail and that he was wanted and that he was a suspect. You could have taken all that out. That's why we cite the Adams case, which kind of stands for this proposition that even if something has inculpatory value, if there is exculpatory value to it, it's reasonable for the court to admit it. And again, where this video doesn't conclusively prove the Commonwealth case, it only works with everything else, and accepting that there was that faint thud, I do think it's very reasonable, even if he failed to hear and perceive the inculpatory value, it had tremendous exculpatory value.
We should probably go the other way, but that begs the question, what if you have an attorney who's slightly hearing impaired? I mean, it was pretty faint. And is that part of fallibility, or you know, are we requiring people to get massive decibel speakers or use a hearing enhancement of some sort? It's kind of an odd where the line is drawn situation here.
I agree.
Can I ask you something? And you don't have to, I'm not asking you this question, but as a matter of record, there is nothing that indicates whether you, as the trial prosecutor, would or would not have sought to offer this particular video. And again, I'm not asking what you would have done.
I think
came into the first witness in a rather odd way, as part of a group video exhibit.
It came in through that witness, and it came in kind of
early on.
As I was in through motions in limine. I had filed a motion in limine kind of generally to admit the videos in this case. Again, there were 4 total. I think what I said, because I also handled the motion for new trial at the district court level, is that because it showed the multiple other vehicles, it was not anticipated that at my case in chief, I was going to introduce that video. Now, certainly at a new trial that would change.
Okay.
Yes.
It would have been helpful for us to have had the motions in limine in your supplemental record
Understood.
appendix.
Okay. Okay, seeing nothing further then, the rest of my briefs. Thank you.
Thank you. Thank you both. Come to the next case on the list, Commonwealth versus Eduardo Mendes, 23P 1210.
Good morning, Justin Dashner for Mr. Mendes. In this case, the judge erred in not giving necessity instruction. In this case, the defendant testified and admitted to a touching of the complainant in the matter. His entire defense rested on the fact that this touching was justified. He argued that it was done by necessity. He laid out in his testimony the 4 points that are necessary in order to for the judge to give the necessity instruction. In the light most favorable to the defendant, he laid out that there was a clear and imminent danger, that there was a reasonable expectation that his action would be effective, and then the third point, which I think is kind of the crux of all of this, is were there no legal alternatives which would be effective? Now, in the defendant's testimony, he argued that he thought she was going to jump out of the vehicle and that he grabbed her in order to prevent her from doing so.
Can I ask you a question? And I don't want to throw you off, but I want to start with the second argument there, because to me it's a more interesting argument, the public policy argument, which is what do you say to that, where he puts himself in a position, assuming that there is a necessity defense here, valid on the facts, he puts himself in a position to afford himself of that defense by violating a restraining order. So, right? So,
Understood.
how does that jibe with the public policy implications against domestic violence, and to say, okay, well, go violate the restraining order, and then when you do that, you can say it's necessity because person's trying to run away into traffic and you grab her so she doesn't go?
Sure. So to that point, there's sort of two parts to this. First of all, I'm not arguing, and he didn't argue, that there was no violation of the restraining order. It's just the assault and battery in violation of the restraining order. And as to the public policy aspect of that, I found it helpful to think about sort of a hypothetical, sort of an extreme in the situation. If he violates a restraining order and gets in a fight with an alleged victim on top of a building, and there is a question of fact as to when he grabs her, he states that she was going to jump off the building. Obviously, from a public policy perspective, we would want, even though he put himself in that position in that case, we would want a person to save that person from jumping off the building. Even if that person had said to the police or at trial that there was a different set of circumstances. If this is what the defendant testified to, then in the light most favorable to the defendant, we should allow him to make that argument and justify his actions. There is nothing in the statute that suggests that the necessity defense is not allowed in this case. Further, it's in the jury instruction itself, in the notes of the jury instruction, that say that justification type defenses such as necessity, self-defense are allowed in this case. As for the no effective legal alternatives, the Commonwealth argues that essentially he could have just stopped the vehicle. It's not real clear exactly where this occurred. However, the daughter did testify that it happened while in a gas station parking lot. It was clear that the vehicle was moving when the complainant was going to jump out of the vehicle. This is in a business district, sort of a main street. Jumping out of the vehicle in this case, I would say, is not an effective, or stopping the vehicle is not an effective means to preventing someone from jumping out of the vehicle, no matter how fast the car is going. There could be other cars around. no matter how fast the car could roll over the person if they actually succeed or accidentally fall out when the car is being stopped. So in the case, under the defendant's current circumstances, he says that the only thing that came to mind was grabbing her and stopping her from falling out of the vehicle. So with that in mind, I think that the implication is that there were no effective legal alternatives according to the defendant, and we must view the light most favorable to the defendant. And sort of talking about that fourth point a bit more, the public policy determination that the Commonwealth brings up, as well as the fact that there's some sort of implication that this defense can't be used, the legislature must make a clear and deliberate choice to preclude the defense. That's not here. The Commonwealth asks that it's implied because they have passed statutes against domestic violence. Well, the case is they've passed statutes against any number of crimes, and we still allow for the defense of justification. So in this case, the defendant laid out that his actions were justified by necessity, and the judge should have given the instruction. Therefore, it mandates reversal as at least to that count, the assault and battery in violation of a restraining order. Moving on to the second point, which sort of compounds this issue and is somewhat related, is a specific unanimity instruction, or lack thereof. Firstly, I argue that this is preserved. I understand that the Commonwealth has a different view of it, and it is a close question here. The defense counsel points out that there is an issue here with there being multiple alleged assault and batteries, yet it's not clear which one is actually being charged or argued by the Commonwealth, whether it's all three. One, the judge points out it's indiscernible, but it does seem to suggest that she's asking why wasn't a bill of particulars filed on this. Well, we're at the trial stage. The jury needs some clarity here. And the reason why this matters is because we have a disputed assault and battery where at the end of the CVS parking lot, he gets out of the car. The complainant says that he grabbed her, reached his arms around her and tried to restrain her. He denies this. And then we have a third-party witness who says he grabbed at her. It's not real clear whether he actually touched her from her testimony. So that is disputed. We have two other assault and batteries that are talked about that happen in the car at different points. It's not real clear how much time has passed. The daughter suggests that this whole event took 20 to 30 minutes. So there's certainly some amount of time that's happened between the various events. The locations are pretty close together. However, the first one is when she attempts to jump out of the car. He argues justification. Now, the jury doesn't have the benefit of knowing that. However, he does say that he tried to prevent her from getting out of a moving vehicle, and the jury might find that to be a reasonable choice in that case. And the second one is the one in which she's hitting herself.
So are you suggesting that the Commonwealth should have charged your client with multiple assaults and batteries?
Multiple assaults and batteries, or in this case, I think the appropriate remedy when the defense attorney pointed out the issue would have been to give a specific unanimity instruction. In other words,
On a single complaint, though?
yes, on a single complaint. They have to decide which assault and battery. They could decide that all three happened unanimously, and that's fine. However, they need to come to a specific unanimous agreement that at least one of the assault and batteries occur. And the problem is that you can have half the jurors decide that they're going to believe her when he gets out of the vehicle and at the CVS parking lot, and the other half say, I think we're going to believe him here because the third-party witness didn't actually see a touching. She said he grabbed at her. And then the other half of the jury says, well, he argued that he was just preventing her from getting out of a moving vehicle. And we think that that was a good choice in that case. Well, we don't know that they were unanimous on any single point of the assault and batteries.
What if we're not persuaded by your necessity argument? Does that affect the specific unanimity issue?
I do think they do somewhat go hand in hand. I think the necessity aspect of the argument certainly exacerbates the specific unanimity problem. However, I still think it rests on its own because a jury could find, even without that instruction, that we have a touching here and we're not going to find that to be an assault and battery because of his justification. So in that case, I do think the specific unanimity argument stands on its own, although I will admit that it is much strengthened by the necessity instruction or the lack thereof that was given here. So I would just point out again that the Commonwealth argues essentially that this is a continuous course of conduct, that it happens very quickly. When we're looking at this, the events are separated by time. However short, and they're very specific and distinct events that happen. There's an argument, she wants to get out, she tries to jump out of the vehicle, right? And then he stops that from happening by grabbing her, and then there's more arguing. And then, again, she starts to hit herself sometime between then and when they park in the parking lot, possibly when they do park in the parking lot. And at that point, that it's separated from time from the other incident of assault and battery. And then they get out of the vehicle, and there's another disputed assault and battery. So while it is a sort of chain of events, they are distinct events, and each one has different justification and arguments from the defense as to whether they happen at all or whether they're justified. Therefore, the jury should have found or should have been instructed to find that each of these happened or any one of these happened unanimously. And calling into question to the verdict here, whether there was a real unanimous verdict, certainly even if Your Honors find that this is not a preserved issue due to the clarity in which the instruction was asked for, or lack thereof, it is still important because the verdict is called into question. I do think that that rises to the substantial risk calculation here. Just a few minutes left. I will turn to the last argument, which talks about the juror issues here. There are several points that I lay out in my brief, but essentially the first one is that there was a hard of hearing juror, and that this came to light at a later stage of the voir dire. And basically, at this point, the hard of hearing juror says, I didn't really hear much of the instructions. I'm a hard of hearing. And the judge says, well, I wish you would have told me that. They have assistive listening devices. This juror could have been allowed to participate. But at this point, it was, I guess, inconvenient for the court to allow this person to participate. And the juror was dismissed. Now, this was not objected to by either party. The problem lies in these situations is that the harmed party is the juror not being allowed to participate because of the
Can I say, assume for the moment that you had this juror and then you had a juror whose first language was not English, so we can in the trial court get language assistance, and then you had someone else who had, I'm not going to come up off the top of my head with a different problem, but you had three different jurors, all of whom wait until individual voir dire at the sidebar to bring it to the judge's attention. And the judge, in this case, I think there were 12 questions, but assume for the moment, because we can, that it's a homicide and that the questions take some amount of time. Is it your position that the judge then has to repeat all of the questions to the general venari individually 3, 4, 5, 10, 20, however many times for each individual juror who comes up and announces late in the game that they didn't quite catch what was going on?
Yes, I don't think my position is certainly not something that extreme. I do think it's somewhat fact-based based on the situation itself. However, in this case, another 5 minutes to allow this juror to participate.
Do we know there would have been 5 minutes?
I'm not sure, Your Honor.
And then how much time it would have taken to get, I mean, they have the machines, but, right.
Sure, and I do understand that, obviously maybe this should have been laid out from the start, suggesting to the court officers, whoever, but it's clear that this juror should have been allowed to participate because of their disability, and the judge didn't allow them to do so.
But what's the evidence that the juror was prevented from participating? In other words, in Haywood, the visually impaired juror worked with the judge in finding a solution to being able to have the evidence explained to him or her by another juror.
Sure.
Is there anything in the record that shows that this juror was eager to participate or wanted to have accommodations provided to him or her?
I don't think that's clear from the record. The record is pretty simple. I didn't really hear the questions. I'm sorry, I'm hard of hearing. I wish you would have told me that. We do have listening devices, but We've already done a lot here, so I'm not going to repeat everything. You'll be dismissed for that. And there was no objection by either party. So,
So doesn't it just fall into the general category of a judge's discretion to manage the courtroom and deal with things efficiently?
well, I think we have a, compliance with the law that should allow people to participate in jury selection, and reasonable accommodations should be made. And the reasonable accommodations here were available, they just weren't made due to that inconvenience. And understanding the point that at some point, we can't delay a trial for days because people didn't hear the instructions and need to go back. But in this case, I don't think that was the situation here. And just with a few seconds left, I'll just talk about the memory expert who was denied because of his profession. I think the judge seemed to arrive at the conclusion that someone talking about witness, who was a professional in witness recollection, would not be suitable to be on the jury just because they would be helpful to the defendant, and didn't even really complete any voir dire about whether they could be unbiased or not. And some
May I ask you, was it because they wouldn't be helpful to the defendant or because they came in with particular bias? Because let's say the defendant testified or called witnesses and the juror, because it's evilly said, well, I discount everything the defendant just said because of my...
Absolutely.
Yeah.
There's no evidence to suggest that that person would have been helpful to either side, other than the judge kind of says, like, I think there's a reference to the defense attorney smiling there, like, oh yeah, you like this. And I think that's because in most cases, a defendant doesn't have that many witnesses. It's mostly the Commonwealth's case, right? But, with that, I'd rest on my brief. Thank you, Your Honors.
Thank you.
Good morning. May it please the court. Stacey Gauthier for the Commonwealth, Bristol County District Attorney's Office. It's the Commonwealth's position that the defendant's conviction should be affirmed here. First, there was no error in the trial judge's refusal to give the necessity instruction because the defendant failed to show that there was, or some evidence that there was no legal alternative that would abate the danger posed to the victim when she was supposedly trying to jump out of the car. Or when she was hitting herself. It's our position that the defendant could have stopped the car, and he didn't show that that would have been futile. In the evidence most favorable to the defendant, this happened in July at 5 o'clock, so it was light out. It happened on Bedford Street, which we know from the testimony is a street that has businesses in close proximity, including the post office, Speedway, and CVS. There was really no evidence presented about whether there was a lot of traffic, and there was really no evidence presented about speed, although I think we can infer that the defendant was not driving very fast because he testified that when she was like trying to jump out of the car, he had to like slam on the gas to like make the car go fast, to like make, I don't know, physics or whatever, gravity, make the door fly closed. So I wouldn't, I would suggest that this is not a case as if they're driving down the highway, 80 miles an hour in the middle of the night in the dark. I mean, it's the day, they're not driving very fast, I would suggest, and it's daylight. He could have just stopped and let her out. I would suggest that this case was comparative to the Commonwealth versus Kendall case that was in my brief. That was the OUI case where the defendant tried to raise the necessity defense, where he drove drunk to bring his girlfriend to the hospital who was bleeding, and the court said that the necessity defense was not available to him because there was like so many neighbors that he, close by. He didn't try the neighbors, and there was also a fire station close by, and he didn't try to get to the fire station. So I would suggest this case is like that. I would also suggest that with regard to the fourth element of necessity, here, the legislator had implicitly precluded the defense in these circumstances because the defendant in this case had a restraining order on the victim, right? So
What if
yes.
we take your earlier example, which is that's late at night and he's driving 80 miles an hour down the highway? Should he let her jump out?
Well, I would suggest that the necessity...
Or, as counsel said, jump off a building. But go with yours, which is 80 miles an hour down the highway in the middle of the night.
Well, I mean, he could still be charged. I don't think...
As a public policy
As a
issue.
public policy issue, right? He's not even supposed to be with her in the first place, right? The legislature is not allowing him to be with her in the first place. So,
But I think you were just arguing it's not as if he was driving 80 miles an hour down a highway in the middle of the night, from which I take, well, if you were doing that, okay, then you should grab her.
well, then maybe he should get the defense and maybe he gets found not guilty. But I think, I mean, generally speaking,
So you're saying
in this
you should not
case-
be able to create the necessity.
that's correct. I cited to Commonwealth versus Espada in my brief, and in that case, that was a self-defense where the court had ruled that you can't raise the self-defense claim if you're the one who started the fight. I had also found, when I was preparing for argument in this case, I have Commonwealth versus Leno, and that's at 415 Mass 835. That's a 1993 case. It involved the defendant who had created an illegal needle exchange, and at the time, needles were only available by prescription, and he created this illegal needle exchange. His excuse was that it was to stop the spread of AIDS. But the court in that case ruled that he was not able to use the necessity defense, first because there was no imminent danger. Any danger was future and speculative. But then they also said that the legislature determined that it wanted to control the distribution of drug paraphernalia, and that public policy was entitled to deference by the court. That's on page 841 of that case. So I would suggest that would be very similar here with the public policy against domestic violence. And I would also suggest that, holding that the defendant is not able to use the necessity case in this instance would not interfere with his right to raise a defense. Again, going back to Espada, where the court ruled, on self-defense, you can't create the confrontation and then, then raise a self-defense claim. And then even I think the defendant in his reply brief had cited to a prison escape case. And I know in Commonwealth versus Thurber, that's the prison break case. Even in that case, the court had laid some conditions that must be met before you can resort to, escaping from prison. So I would suggest there was no error in not allowing the defendant to raise the necessity defense. There was also no error in the judge's refusal to give the specific unanimity instruction. The facts here show a continuing course of conduct. And if you look at the prosecutor's closing argument, when she went through her closing argument, she went through each specific charge. And as far for the assault and battery, in her closing on page 93, she had stated that with regard to the assault and battery, the defendant took the stand and he told you he knew there was an active restraining order, and he did in fact put his hands on the victim more than one time in the car, and then when he was trying to pull her back into the car. So she limits the acts, the assault and battery acts, to just the car. As far as the grabbing of her in the parking lot that was witnessed by the civilian, those acts she describes, like in the next paragraph, those she put towards an assault on a household or family member, which charge the defendant was ultimately found not guilty on. So she limits the acts to just that, the specific time when he was trying to grab her to keep her in the car, and then when she was getting out when he was trying to grab her. So I would suggest they are temporally and spatially short and close. I think it was the daughter who testified that the entire incident from the post office to the CVS was about 20 to 30 minutes. So then you close that up even more, because now the assault and battery, the prosecutor is just talking about those incidents in the car. And then again, they're close in time, right? It was just when she was in the car. I'm sorry.
20, 30 minutes, for the purpose of a specific unanimity instruction, it seems to me 20 to 30 minutes is not a small amount of time. If there's if there's an assault here and then 30 minutes later there's another push, I think those are pretty distinct.
Right, that's true. And what I'm saying is it wasn't even that. She limited it even further into just the car. And then the other grabbing outside the car, that went towards like I said, the assault, which she was found not guilty of.
To the extent the prosecutor did separate the touchings out in the closing arguments, why would it not have been appropriate for the judge then to give either a specific unanimity instruction or at least a verdict slip that indicated, and I don't know if we have verdict slips, because a verdict slip that indicated which physical act went with what charge?
Well, I mean, the defendant didn't ask for a specific jury instruction, and I would also suggest, you know, he didn't ask for her to give the specific unanimity instruction. He wanted her to have the Commonwealth point to, you know, one specific incident, which I would suggest that the Commonwealth didn't have to, based on how they charged the defendant. And so she didn't. I would suggest she wasn't required to, because it's all a continuing course of events. And then with regard to the final issue on the jury selection, I would suggest with regard to the hearing impaired juror, there was a hearing impaired juror who came up to the bench during the individual voir dire, and the judge found out at that time that she was hard of hearing, and thus the judge was unclear whether she heard like the 12 prior questions, plus the explanations of law that went along with those questions, plus the witness list. You know, it was unclear that the judge heard those. There was no objection to her excusing that juror for cause. So I would suggest that it was within her discretion, as a judge to challenge her for cause. The juror, I don't believe she made any statements that made it seem like she particularly, wanted to be a juror. So I would suggest that that was proper. And then with regard to the juror who had some kind of an expertise in memory, I would suggest that she properly excluded this juror based on bias. I mean, he had written on his juror card that he essentially couldn't be impartial. He stated that he had serious concerns when it came to eyewitness testimony. And then the judge told him, well, this is a DV case, there's no eyewitness testimony, although there actually was one eyewitness. So then he kind of pivots. And so now he's like, well, nobody's memory is really good. Everybody's memory is bad. Attention is awful, and people can think that they're telling the truth, but, they're not. So basically he was saying that he couldn't trust someone's memory. And I mean, at that point, he's not going to believe any witnesses, I guess, because everybody's memories is so bad. If he doesn't believe anybody's witnesses, then I guess that goes to the defendant's benefit, right? Because if you don't believe anybody, then obviously it's a not guilty. So I would suggest that she, was within her discretion to strike that juror for cause. Thank you. And if there's no further questions for anything not addressed, I'll rest in my brief. Thank you.
Thank you both. All right, we'll proceed with the next case on the list. K. William KRIKORIAN and another versus Harness Horsemen's Association of New England. This is 24P 462.
Good morning, Your Honors. Attorney Scott Lathrop on behalf of the appellants, William KRIKORIAN and William Abzonor. This was a case that was decided on a directed verdict. And it's basically our contention that this case should have been decided by a jury, not by directed verdict. In terms of the underlying event, understand that, as you certainly well do, that my clients, the plaintiffs, they were members of the Harness Horsemen's Association of New England, and they were members since dating before 2013. And that date is relevant for reasons I'll state in a little bit. And the issue revolves around, factually and legally, their reapplication for annual membership in 2018.
So is it the 2018 membership application that the defendants breached? What's the contract that was breached?
What we're saying is that they were current members going back to a couple of years before 2013, and in a little bit I'll tell you about the importance of 2013. And they had annual memberships that they had to submit, which they always did. And the factual legal issue that's underlying almost the entire case is that they submitted in the spring of 2018 a reapplication, if you will, or
With the part of it crossed out.
yes, and that's the dispute. But in terms of it's not disputed that up through 2017, they were long-term members in good standing. There's no question about that.
Isn't each year a new contract? And if Hain decides...
Well, that's one of the legal points I'm going to argue, okay? And what I'm going to argue is that, I mean, my brother does argue saying, hey, their membership expired December 31st, 2017, so therefore when they reapplied in the spring of 2018, it was starting a whole new relationship. We argued that, indeed, there was an ongoing relationship. Mr. KRIKORIAN testified in part of direct that there was a grace period, he called it, in terms of...
So let me ask the question that Judge Kenton Walker asked. What's the contract that the defendant breached?
The contract that was breached was the bylaws, because the bylaws say that members can reapply by simply submitting the application by May 31st and paying the annual dues.
The application, though, seems to me just plain, simple interpretation is the application, not with everything that you don't like about the application crossed out.
Yes, they did cross out that, but hear me out.
So how does that, but I just don't, how is that still the application?
Well, again, we're saying first that by the bylaws, all they had to do is reapply and submit the checks, $25, I believe it
the
was.
bylaws say all applications for membership shall be made in writing to the local Hain office. Annual dues and signatures of the applicant are required. So if Hain changes the application form, does any change to the application form amount to a breach of the bylaws?
Well, the breach wasn't in terms of, oh, they added language, but when my clients struck out the language that said, you're agreeing that HHA&E is the exclusive representative in dealing with Plainville, and they testified as part of direct that that was a condition that hadn't been approved by the board of directors. So adding this condition was adding a condition that was beyond what's in the bylaws, so breach of the bylaws. We're saying that. Now, my brother in good faith argues, well, gee, their membership expired on December 31st, 2017, so therefore they didn't have an ongoing contractual relationship. Obviously, we argued, and I would have liked to argue to the jury that, no, there was an ongoing contractual relationship. Indeed, I may have already said that Mr. KRIKORIAN testified that there was a grace period up until...
Right. Don't they concede that even given the grace period?
They didn't, and I'd like to point something else out.
So does something happen in between December 31st and the grace period? I must have missed that.
I'm sorry,
Does something occur in between December 31st and the end of the grace period?
What occurred was that they reapplied and submitted the checks. But yes, I want to bring one other...
No, but then it was sent back to them and with the request that if you want to be a member this year, you need to fill out the actual application. And then nothing happened, right, between then and the actual ending of the so-called grace period?
Correct.
Okay.
My clients didn't, by May 31st, submit a, shall we say, a clean application without anything else.
They were told you need to submit.
I'm sorry.
Your clients were told that you need to submit a clean application by May 31st, or you're not going to be members, and you're going to lose the opportunity to vest in the new retirement plan.
Well, that's inconsistent. Let me point out to you, and I would have everyone look at Exhibit 20, which is in the Record Appendix number 2, pages 43 to 44. And this was a news from our executive director, Carol Malcolm. And in that, she indeed states, remember that your membership expires on the 31st. But then, let me quote the language, and this goes to both breach of contract and fraud, because this is what she says to all current members, including the plaintiffs, quote, "To remain an active member, you must renew it by submitting a new application with your annual $25 annual dues before May 31st of the new year." She didn't say to become members again, you must do something. To remain. So they remain.
When was that? I'm sorry, when was that sent?
I'm sorry.
I'm sorry, yep, when was that sent?
That was sent on April 26, 2018.
So within the grace period?
Yes, and my clients comported with her directive, that they filed it, their application.
But they didn't submit, they submitted an application, but it was a redacted application.
It was a redacted, but again, I'd want to argue to the jury that by imposing Carol Malcolm, by imposing that condition, breached the bylaws and misrepresentation to her own.
What was the evidence in the plaintiff's case in chief that Carol Malcolm did not have the authority from the board to to send those letters requiring the plaintiffs to submit unredacted applications?
Both plaintiffs testified, and understand that they had served as directors, that the board of directors had not approved the language that they struck. Now, granted, a jury could not believe them or something else, but that's for a jury to decide. But this was their evidence.
What were the annual membership dues?
$25.
$25. So let's just say, for example, that they say, well, we think that's too much, and this year we think we should only have to pay $5. Here's my application, here's my check for $5, or here's a $5 bill. And then they say, well, we sent it in, and we sent in a fee. Maybe not the fee you're asking for, but it's a fee.
That I would say, that the applicants didn't comply with the condition. Again, even Carol Malcolm's notice on April 26 says your $25 annual dues, and there's no dispute that they submitted the required dues.
No, right, I got you.
Everything goes just to this stricken language, which the testimony by the plaintiffs was that was not approved as a condition by the board of directors. So therefore, they exceeded the conditions based upon.
So it sounds to me as though your argument rests on the plaintiff's testimony that they know that the board did not approve Carol Malcolm's conduct, but they weren't members of the board at the point in time when they say the board didn't approve Carol Malcolm's conduct.
My memory is, now remember, the defendants didn't even testify because there was a directed verdict, but my memory is that there was no cross-examination disputing the notion that that language was unapproved. Okay, so even on cross-examination of the plaintiffs, their testimony stood that that condition was not approved. Okay? Now, the other issue that arose here was this issue of damages. Okay? And understand that starting with Mr. KRIKORIAN, let me back up. Obviously, forgetting about computing damages, the basic damages that occurred, and this is undisputed, is that because their 2018 membership was not granted, but then they, in 2019, submitted thereafter, that for purposes of the HHA&E Retirement Savings Plan, their, I'll call it credited service, actually went back to 2019.
The judge made an evidentiary ruling that your clients needed an expert on the subject of computing damages. Where in your brief, on what page do you argue that that evidentiary ruling was wrong?
On multiple pages, I argue that it's wrong. Furthermore, please understand, and please review Record Appendix Volume 4, pages 44 through 60. That's the entire debate that we had by sidebar in terms of my clients attempting to testify as to their damages, which the judge would not allow. Again, I disagree with that. But also understand the following. This, again, I'm calling it credited service. So the the damages occurred was that credited services for when they retired would go back to 2019, not 2013. That's when the plan was established. So that's the relevant date. They were all members during that period of time. Understand, now this trial occurred in March of 2023. The plaintiffs hadn't retired yet. So I would have been perfectly happy if the jury came back ruling in our favor that the judge order HHA&E, when they retire, give them credited service back to 2013, not 2019. Because again, forgetting about computation of it, in essence, they hadn't yet incurred the damages. The damages would occur when they retired, which they hadn't done as of March of 2023. I don't think they've retired now even, but so they're still active members. So the damages is, in one sense, a conceptual one, which wasn't even disputed, that in fact, you know, their credited service goes back to 2019 because they have, I'm calling it a break-in service in 2018, not going back to 2013 when the plan was established. They actually were members even before that. But so I'm saying that a directed verdict, as opposed to letting the jury decide, is there evidence of breach of the, you know, and does the bylaws apply to them? And again, Ms. Malcolm, the person who denied their application as inconsistent with the very same news representation she made, and they precisely followed. So that goes also to the fraud issue.
What do you do with Mr. Abdelnour's testimony on cross-examination at RA4, page 114, that as of May 2018, you knew that HHA&E was telling you that if you didn't submit an altered application by the May 31st deadline, your entitlement for benefits under the RSP was being threatened. True? And he says true.
Yes.
So he knew if he didn't submit an unredacted application, HHA&E was going to tell him, not Ms. Malcolm, but HHA&E was going to tell him, you're not eligible to participate in the plan.
And he stood up for his rights, which is why we had the litigation. So he didn't have to comply because, again, we can get into it, but the record establishes that as these people were ex-directors, there was in essence a political dispute going on between the current directors and the head of HHA&E and my clients. And that's why they struck out the line, exclusive representative, which was a line added without the authority of any board vote, and this becomes something political. So my clients stood up for their rights and said, no, we don't agree with that, and we're not giving you the exclusive right to negotiate with Plainville.
One quick question about the record appendix. At what page of the record appendix is the Superior Court docket?
I don't know off the top of my head, Your Honor. I
To
apologize.
include a copy of the Superior Court docket in the record appendix?
As far as I know, it was included.
You might want to check.
I'll have to. I don't remember off the top of my head. I apologize.
It needs to be included. It looks to us like the litigants are keeping from us what happened in the trial court when we don't get a copy of the docket.
If it was overlooked, I apologize, but I thought that was all included. And I did not, in preparation for today, I did not go back through it looking for that one way or the other. And if it was an oversight, I apologize, but no, there was absolutely no intent to hide anything from this court. Anything further?
Thank you.
Okay, thank you.
Good morning. My name is Mike Liedberg for the appellee in this case. At the outset, I would like to inform the panel that in preparing for the oral argument today, I realized that the cross appeal that I had filed needs to still go before a single justice. regardless of the fact that it was brought in the context of a cross appeal. I realized that as I was preparing. I'm not going to argue that today. I spoke.
Do we have jurisdiction to
do
hear the
not.
cross appeal?
You do not. It needs to be heard by a single justice. So I spoke with the clerk, and he indicated that it would just be held in abeyance until this goes as far as it can go, and assuming the appellee prevails, then we can renew that. So I apologize for including that in my brief, but that will not be argued today. I think the court panel was right on point that where's the contract? You know, to have a contract, you have to have offer, acceptance, meeting of the minds, consideration, all of those things. We don't have that here. And I don't think that's been articulated in any cogent way anywhere along the lines of this case, whether in the trial court or here today. There is no, under the Espinola case, there is no contractual right.
Don't you have a better case than Espinola from 1951? Judge Kenton Walker asked you that.
I thought it was right on point. I didn't look for anything newer. Well, I didn't see anything newer that Espinola, that had cited Espinola for that principle. And admittedly, there's some aspects of Espinola that are probably outdated, mainly the fact that they were excluding a woman from their membership.
So you couldn't find a case more recent than 1951 on the question of when parties to a contract don't agree on its terms, no contract is formed?
I could not, and I also could not find anything contradicting it. And I think it's still good law. A voluntary association, there's no contractual right to membership in a voluntary association. The cases cited by my brother deal with people that are already shareholders in a corporation. They have rights under the bylaws. They have property rights. It deals with, another case deals with members of a religious association having rights under the bylaws. But this case deals with the threshold question of were they members in good standing at the critical moment in 2018 when this RSP was rolled out. And I think that is a distinction that's critical to the case. You don't have a right to membership in a voluntary association. It's very clear. Hain drafted its bylaws. The plaintiffs, the appellants at one time were on the board. Mr. KRIKORIAN, I believe, was the chairman of the board, and actually was charged with enforcing those bylaws. And they quite clearly say that Hain has the sole discretion to determine membership, to determine who is a member in good standing. There is no perpetual, forever right to be a member of Hain.
Can I say, are these folks, just out of curiosity, mostly horse lovers and riders, or kind of more like gamblers and going to the track people?
Well, I don't know what happens at Plain Ridge on race day, but I'll tell you that there's an association of racers and trainers. There's two different groups of folks, and the purpose of Hain is to advance their profession as a whole. It's a nonprofit. It's not to benefit financially. There's no financial benefit, but to benefit. And how they do that, the very essence is they negotiate with Plain Ridge on race issues. In this case, it was the stabling, off-season stabling of horses, and they negotiate from a point of strength. When you've got the whole New England, racing group, this is a very, it's the only track in the area where this happens. So when you've got every single harness horse racer, arguing for certain things, you're going to have strength in numbers, and that's the purpose of the language that the appellant struck out. But the important thing, I think, is even if we were to stretch, what I would respectfully say is a stretch and say, okay, well, sending out these renewal applications is an offer, is an invitation. Well, if it was, then they rejected it by changing the terms. There was a counteroffer at best when they sent back the applications with the things stricken out. And to say Ms. Malcolm didn't have the authority to look at it and say, wait a minute, you altered the application and send it back, that's not a substantive membership decision. That's a decision that could be made by anybody. You didn't send the check, or you didn't send, you altered the application. You can't set the terms of membership. We set the terms of membership. If you don't like them, go somewhere else. But they testified at trial. They wanted the benefits of membership, but they didn't want to abide by the only real substantive material term. And that's, we deal with Plainridge, not you. You can't go behind our back because that undermines the very purpose of the association. The damages issue, and again, I looked at Appellant's brief. I didn't see any challenge to the trial judge's ruling that was actually issued with a forewarning at the trial conference. You're not going to be allowed to testify to damages in this case. And that's important because the damages aspect goes to both claims as to whether or not they had merit. The way that this RSP was funded through the Horse Racing Development Committee, I think it's called. It's a subset of the Massachusetts Gaming Commission. They fund it. They had to approve the terms, and they fund it. And what they do is they have an annual allotment that's paid from taxpayer money or from taxes paid on gambling proceeds, and it's a set amount every year. And there's a complicated formula. We actually have an accounting firm that does this every year, that goes through and says, all right, who's eligible? And after you determine eligibility, which you have to have a number of races during that membership year, they also award points. So people with more races under their belt that year get more points. And then you take that set sum, you subtract administrative costs, and then you distribute it out to the people that enrolled and the people that are members in good standing, and that's how the distribution goes. For them to say,
how large is the membership, just out of curiosity?
I'm sorry?
How large, what's the membership? Is it hundreds or thousands, or do you know?
It's not thousands. It's closer to 100, I think, maybe even less than 100. But it's still a complex situation because you have to add them into the pool of eligible participants, calculate their racing history, which, by the way, they entered zero evidence of at trial, no racing history. Neither one of them talked about their racing history. You cannot calculate the benefit without that. But it's a complicated formula. It's not just, divide it by 12 and that's the benefit for the year. There's points and whatnot. And I think one of the most perplexing things in this appeal is that Mr. Abdelnar didn't even fill out an enrollment form in 2018. This look-back benefit that's at the inaugural year back to 2013, this look-back benefit was a one-time deal. If you didn't get on the train at the first stop, you weren't getting the look back. And that was just a nod and homage to people, longstanding members. We want to give you credit going back 5 years for your initial allocation. He didn't even apply. I don't know why he would think that he would ever be entitled to RSP benefits under any circumstances. But this isn't about a perpetual ongoing relationship.
I have a question for you about the record. In the transcript, there was a document that was referred to as Exhibit 25. That was a bunch of an email things that were sent in May 2018. I can't find that in the record appendix. Is it in the record appendix?
We had a third party look through that, and I apologize if it's not, Your Honor. And I tried to access my online thing through the court's guest Wi-Fi, and I couldn't do it. So I can't answer that question, and my sincere apologies. But that was an email blast. There was one that went out in 17, too, that was on the record. But it was basically just an email blast reminding people, you got to be members in good standing to get this benefit. And I think that's an important point as far as membership in good standing. The plaintiffs, the appellants are essentially arguing for a perpetual right to membership. We're not saying there was a contractual relationship and then there was we're arguing there should be a new contractual relationship. We don't think there's a contractual relationship here at all. I mean, they might have some property rights in the bylaws when they're active members in good standing. But that's not what this is about. It's about them not renewing their application. We didn't remove them from membership. Age 65 requirement, that applies to people that are active members in good standing that enroll in the RSP. All that says is if you're already 65 or older, you're all automatically vested in whatever benefits you may or may not be entitled to. These are all provisions that assume that you're a member in good standing. And when they chose their little coup d'etat, that they don't want to abide by the terms when they chose that, and when they chose it in the face of Ms. Malcolm telling them, you are going to lose out on the RSP, you're going to miss the inaugural year, they were undeterred, and now they want the court system to rescue them from that decision.
So you're saying that they don't have any recourse. What if they had not crossed out that language and they had submitted the application appropriately in your view and submitted the check and it was still not accepted? What's their recourse?
I don't believe there would be, to be honest with you, Your Honor, because they have the sole discretion to determine membership. If they don't like you, I mean, I would submit that the Espinola case would probably be no more nuanced today. If they said, we don't like men, we don't like your ethnicity, I think that would be a different story. But beyond that, they reserve sole discretion to determine membership, and I think they can reject your application.
Does it matter that that sole discretion language is only in the plan and not in the bylaws?
I don't think so. I think that they created the RSP. I mean, if we're talking purely in the context of the RSP, I mean, it might matter if they were talking about life insurance benefits or something else, disability benefits or something else. But in the context of the RSP, I think that's the key language. You need to be a member in good standing, and we reserve the right at our sole discretion to determine if that's the case. I think perhaps if there were members in good standing and they denied them participation in the RSP, I think that's when you're talking about there's a property right here that's being infringed upon. But that's not our case.
Where in the plan does it explain this look-back period?
Oh my goodness.
So 6.1 that talks about vesting, it says each participant shall acquire 100% vested interest in the amount credited to his account when he's accumulated 5 consecutive years of vesting service. And then it says, except as provided below, somebody with less than 5 shall not be vested. And then somebody who's actively engaged. Now, they were actively engaged, and they were at least 65 years old. So once they joined in 2019, do they vest then?
They are vested now. In fact, they did finally fill out an application.
But they lost the 5 years.
They missed the boat on the look-back period because that was only an inaugural thing.
So where is it in that emails that explains the look-back period with for the inaugural benefit? Where does it talk about that?
I know it's right in the plan. I have it on page 13 to 14 in my brief, and I'm citing to, again, I can't actually access the record appendix, but RA1, page 55, 57, and 58. And I don't believe it's in the vesting section. I don't believe that's the case. I think it's in the benefit calculation section where they say, for inaugural members something to the effect of our inaugural members will look back to 2013 and give you credits and points for all those races that you had for that 5-year period. Now, the fraud case, we didn't even hear about it today, and that's troubling. That case is primarily the basis of why we're seeking fees under 6F for the appellate costs here today. There was never any case for fraud. For the life of me, I can't figure out why this made it past the Rule 12 stage. They didn't plead it with particularity, as is required under Rule 9B. A week before trial, counsel could not articulate the basis for fraud other than to say we didn't follow the RSP for political reasons. Well, that doesn't magically transform the RSP or the bylaws into a misrepresentation of fact. If that's the case, then every single breach of contract case in the Commonwealth is also a fraud case. That's not a representation of fact. That is a simple membership provision that they're allegedly misapplied, and it's not a misrepresentation. It's not a material misrepresentation. There was no evidence of anything on the fraud spectrum. And whatever can be said about the 6F decision below to deny my client's motion, to come here to this court and still perpetuate this claim without basically having checked off any boxes on the breach of contract or the fraud count, I think that warrants costs. And with that said, unless
I
there's a-
don't understand how it is, you moved to dismiss your abusive process claim that sought attorney's fees with prejudice, and the judge allowed that. And then you turned around and filed the 6F motion seeking attorney's fees.
We filed the
Isn't that a contradiction?
we filed the 6F motion first, Your Honor, right after trial.
Okay.
Right after judgment was entered, we filed the 6F motion. That was denied. We made a decision, a tactical decision, that if the court's not going to allow 6F sanctions, they're probably not going to find much on the abusive process claim. But that claim was bifurcated, and we just decided we're going to dismiss that and pursue this once they appealed.
Any other questions? Thank you very much for your
Thank you.
argument. Thank you, parties. And we move to the final case on our list, John Doe 2534 versus SORB 23P 1122. And just a reminder to parties, this is an impounded matter.
Good morning, Your Honor. Your Honors, I'm Attorney Colin. May it please the Court, I'm Attorney Colin Caffrey, and I represent the appellant Doe 2534. On 1/11/2001, Doe pled guilty to 4 counts of rape of a child by force and was sentenced to 20 to 25 years. At the time of the hearing, he was still incarcerated. Doe is now a 70-year-old man with diabetes and a history of heart polyps. Both before and at the hearing, Doe moved for expert funds to discuss how the nexus of his heart problems and diabetes would affect his risk of reoffense and risk of dangerousness. The hearing examiner, again, both before and at the hearing, denied this motion with minimal reasoning, indiscernible reasoning. The hearing examiner merely mirrored the language in 803 CMR 1164A. However, Doe actually met the requirements of the CMR. Contrary to the hearing examiner's brief conclusory analysis, Doe showed his special circumstance, the nexus of his age and health. He ID'd a witness with expertise who could testify on his behalf, and he provided documentation, more than 50 pages of medical records. This was not a general or generic motion for funds. Doe ID'd the unique circumstances that were not covered by the regulations, and it was an abuse of discretion for SORB to deny his motion for funds. The hearing examiner did not have the expertise to evaluate the nexus between Doe's health and age. The regulations did not imbue the hearing examiner with that expertise. Doe 58574 demonstrates this. In that case was remanded because SORB denied that Doe an expert to testify about the nexus between hepatitis C and interferon and how they could create decreased libido. This court remanded because, again, SORB did not provide funds. And this certainly could have had a bearing on the hearing examiner's decision. While the hearing examiner did say he gave Doe's age full consideration, that's sort of empty consideration after noting that Doe committed his last offense at an age when offenses usually tend to decline. He later stated that this was significant. And while the hearing examiner said he gave factor 31, physical condition, minimal weight, he didn't explain why he gave the hearing examiner that factor minimal weight. And he gave it minimal weight after noting that he was only doing so out of an abundance of caution, and that that Doe's physical condition was not likely to prevent him from committing any future offense. I mean, this was a topic at the nexus of the health problems and Doe's age was certainly a topic beyond the ken of a hearing examiner, and he needed to have an expert to assist him. Doe never even got the chance to make his case as to how his age and health would have affected him. The hearing examiner also erred by finding that Doe's second victim was not an intrafamilial victim. In fact, at the hearing, SORB admitted that the second victim was intrafamilial. At the SORB hearing, the SORB attorney stated this was also an intrafamilial case.
What if they were wrong there? So speak to not what they said, because they're saying something different now, if that's what they said, but how is that a family member if it's a person who you live with for a couple months, child?
Well, I think, again, the record belies the fact that this was only a couple months. The hearing examiner found that this abuse started when the victim was 7 or 8 living with Doe. And the final act of abuse that led to the discovery occurred when the victim was 10 years old living with Doe. That's a period of 2 or 3 years where it seems like they were living together at least on and off. And this was, he had been dating her mother for 8 years prior to the abuse. And it said they had lived together since 1997 when the abuse occurred. You know, he pled guilty in 2001. So they had been living together for a significant period of time. This was someone who was clearly a family member substitute. I think the case law also sort of says close enough is good enough. If you're close to the regulations, that's sufficient. And this was an error. This was prejudicial because by not finding an intrafamilial relationship, the hearing examiner was not able to make the required findings that are required by DOE 496501. It requires explicit findings regarding the efficiency of publication.
Can I ask you a different question? If you could address, just for a moment or as long as it takes, Mr. Shinai's argument that there were 4 arguments not raised before the Superior Court and therefore waived. Those are that the examiner made a mechanical checklist analysis of the risk, that the examiner failed to consider that the sex offenses were limited to intrafamilial victims, which we just discussed, that the examiner failed to adequately credit Doe for health issues and stability in the community, and that the examiner gave excessive weight to the criminal history. Those were not, at least as I could tell, raised before the Superior Court. So why are they not waived here, or were they in fact raised?
I certainly can speak to that. I will say that the cases that my brother cites for the proposition of waiver, he cites DOE 3974 and DOE 203108. I don't think support the idea that these were waived. In DOE 3974, the case was, the waiver was based on facts that were not before the board, and it had been couched as a jurisdictional issue. Here, these facts certainly were before the board. And secondly, the DOE 203108 case, again, it was a lack of objection to multi-level hearsay, and again, there was a lack of developed record. There certainly was a developed record here before the board. I'll also note that I believe in the motion for Superior Court review, the 30A motion, the attorney below did raise the substantial evidence. And I think this would certainly go to substantial evidence as to whether or not he should be a level 3 offender. And I also note there's, even if the court were to find that these are waived, there's the judicial economy. The court could address these issues on the basis of the judicial economy, particularly since these issues are what are likely to arise at at DOE's next classification hearing. It would be helpful for SORB and DOE's attorney below to have guidance as to how to handle these issues, and there's also a public interest in avoiding overclassification. And I'll also say that the hearing examiner's errors prejudiced Doe. While I think the record shows that Doe, adjusted well to incarceration, he was employed throughout his time while incarcerated. He was heavily involved in religious organizations there. This was certainly prejudicial. This wasn't a case where the outcome was sort of predetermined, where the errors didn't have an effect. And again, I'll note that Doe is now 70 years old. He has a nexus of, he has heart problems and diabetes and serious health problems. He should have had an expert to opine on that and how that affected his risk of reoffense, and he should have been able to, the hearing examiner should have considered whether or not the intrafamilial relationship made it less likely or made the efficiency of internet publication less.
Well, the intrafamilial relationship is factor 7, right?
Yes.
And the hearing examiner didn't mention factor 7 at all in their findings, right?
No, they did not, Your Honor.
What do we do with the fact that the hearing examiner mentioned that the mother of victim 2 said that she knew that Doe was not supposed to have contact with children, but she didn't believe anything had happened with victim 1? Isn't part of the reason for factor 7 the idea that that family members are going to know about what happened to other family members? And here where the mother of victim 2 didn't believe the allegations involving victim 1, doesn't that increase the need for internet publication?
Well, Your Honor, I'll note that reducing Doe was classified as a level 3 in this proceeding below. So even if it were remanded, and even if he were to have the benefit of experts and the benefit of a consideration for intrafamilial, it's still possible he could be classified as a level 2, where there would still be some level of dissemination and some level of publication of his status. And I'll also note that I would argue that that's a decision for the hearing examiner to considering the intrafamilial. When there's a factor misapplied, the remedy is remand for the hearing examiner to sort of balance how, the facts that Your Honor mentioned interact with the fact that he's intrafamilial. The hearing examiner would be in the best position to balance those.
Anything else?
If there's no other questions, I'll rest on my brief for the remaining arguments.
Thank you. Counsel.
If it pleases the court, David Shania for the board. The board's position is that the hearing examiner properly denied the motion for expert funds. The case law is pretty clear, as well as the regulation that was developed after 89230. There's a burden on the offender who requests funds.
So what was missing in the proffer?
The proffer didn't explain that this individual had any limitations, physical limitations, that would possibly lower his risk or danger. All it said was he suffered from these ailments, and that that he would like an expert to evaluate him, evaluate those medical issues and his age, and taking those together to determine what this individual's risk is.
So you can't get the expert to tell you what the limitations are? You have to.
No, because the proffer has to indicate there are limitations. Like the hepatitis case, I argued. In that case, there was information provided to the board and later to the court that said that the medication, Interferon, causes a lowered libido, and it also causes sexual dysfunction. So there clearly it should have been an expert given at that time, although I argued against it and failed. The expert should have been given because there was evidence submitted that the protocol this individual was on could cause this type of reduction in sexual activity. In this case, none of the evidence, none of the medical records even talked about physical limitations, such as walking, such as being able to lift things, to those kind of issues. In fact, in 2018, they declared, the medical records said that the individual felt well and that they were going to treat him with medications. So there didn't seem to be any physical limitations in the records regarding the medical issues. And I think under those circumstances, the hearing examiner properly denied the motion because of the lack of the proffer causing a causal connection to some limitation that would indicate a reduction in risk or danger. I think the Factor 7 issue, that's interesting in the sense that Factor 7 basically is saying, it doesn't say having intrafamilial victims automatically reduces risk. It says it may reduce risk in certain circumstances, but that intrafamilial does not necessarily increase or decrease an individual's risk or danger. And that is because in this circumstance is a good situation. The individual was living with a woman, as we probably would know, probably till about 1991, and had been sexually abusing her daughter, whom he raised from childbirth, or helped raise from childbirth. And by the time she was 6 or 7, he was sexually abusing her on a pretty regular system. In fact, I think the indictments have the period, a 3-year period from like 1989 to 1991. He's, in 1996, when it's alleged that he had done these, in 1995, when it's alleged he had done these things, at that point, somehow he is living with another woman, or he finds another woman who has a prepubescent daughter, and he begins sexually assaulting that child. Now, the idea of an intrafamilial victim idea is that if you limit yourself to family members, or if you've been living with a family for 2 years and start sexually offending a child in that, limiting it means that you're not going to go outside the family network and look for other victims. That's the whole idea of an intrafamilial relationship. In this case, this individual went and found another woman who had a prepubescent child that wasn't his, that he wasn't the stepfather of, and he began sexually assaulting her at a very early period in their relationship. And actually, by the age of 10, he impregnated her. So I think that that idea that somehow if we go back and give him credit as an intrafamilial sex offender, it's still not going to lower the risk he presents. I think the bigger idea in this case is the fact that this individual has been incarcerated since 2001. He had substance abuse issues and refused substance abuse treatment. He, as of 2001, refused sex offender treatment. So he's had no treatments in those areas. He has no support network when he gets out or upon release. He actually kept stating that he was waiving parole because he would be homeless upon being released. So there's really an issue about stability. There's an issue about when he's released without having had any type of substance abuse counseling, without having any type of sex offender treatment, or having limited sex offender treatment because he had some treatment prior to 2001. And the fact that he has no support network in place and would be homeless and had no employment lined up, so to speak. I think that goes to the bigger issue of why a level 3 was justified in this situation, based on the type of sex offending that he engaged in much earlier in his life. And for these reasons, unless there's specific questions, the board, I think I've addressed these issues, would rest on my brief.
I do have one question. That's about the waiver issue. Can you respond to the response to your argument about waiver? In other words, why the classification arguments raised that you say were not brought before the Superior Court, and I think counsel distinguishes the cases you cite?
Well, I think if you take out those cases, there's other cases that are non-SORB related that specifically say issues not raised in the Superior Court cannot be raised at the appellate level. Now, what's interesting is years ago I used to use the older cases that were non-SORB cases, and Justice Dickoff wanted to know why I wasn't using the SORB sites, so I had to start using the SORB sites.
Can't lose for winning or win for losing or whatever.
But I still have the old ones somewhere stashed on my computer just in case there's ever a change, and I can go back to those because those were also pretty effective.
I have a question for you about Factor 7, where families may be changing and the definition of what is a family. should we be concerned about the fact that the hearing examiner didn't explicitly decide if these relationships were intrafamilial or say whether or not Factor 7 applied?
I think the thing is, I think the case law pretty much says that if a factor doesn't apply, the hearing examiner is not required to look to that factor or cite that factor because it doesn't benefit an offender. I understand what you're saying about changing relationships and changing familial relationships, but I think the definition that the board is still using is pretty effective. It doesn't limit it to husband, wife, father, daughter. It specifically says that it includes caregivers who have been with the child, living with the child for 2 years or more. If it's less than 2 years, it's still not an intrafamilial relationship. So because the factor really doesn't define and specifically say it has to be a female and a male or in that kind of situation, I think it covers that. And I'm assuming, I'm hoping, the new regulations may be more specific on that when they do come out. There's been a glitch in that. They were supposed to come out next month, but I guess after the public hearing, CPCS wanted more input, so it's been held up a little bit longer. I personally haven't looked at them because I want to have deniability when I come in to argue these cases and start defending the new regulations. This will be my third set of regulations I've been defending, so we'll see how that goes. I hope I'm not going to be doing this long enough for a fourth set. So unless there's any specific questions, I would rest on my brief.
Thank you.
Thank
you
you.
both. So at this point, this concludes the sitting for today's session. I want to thank all of the staff and members who made today's sitting possible. Thank you.